Tia Wimberly. On the night of November 11th, 2008, a 15-year-old honor student in Fort Lauderdale sat in her bedroom and sliced her own arms with a razor more than 90 times. She texted friends about wanting to end her life. Less than 12 hours later, she walked onto her high school campus with a concealed handgun, and someone else would never walk out. Tia Wimberly had been handed off to her grandparents when she was 6 weeks old. Her childhood was a procession of harm. She was abused as a young girl by her uncle, beaten regularly by a bipolar mother who drifted in and out of her life, and left emotionally shattered when her father was sentenced to 25 years for attempted murder less than a year before her own crime. She was a sophomore in the Magnet Arts program at Dillard High School, studying music and writing poetry, and she had privately come out as a lesbian, but kept it hidden from her deeply religious grandparents. Amanda Collette was also 15, a student at Dillard High who had been Wimberly's closest friend since elementary school. Somewhere along the way, Wimberly developed romantic feelings that Collette did not return. The friendship fractured, and the two stopped speaking entirely. On that Wednesday morning, around 11 o'clock, Wimberly smuggled a chrome-plated .22 caliber semi-automatic pistol onto campus. She found Collette near the vending machines, and after a brief exchange, she fired a single round into Colette's upper back as she turned away. The bullet tore through her lung and lodged in her heart. Collette was rushed to Broward General Medical Center, where she was pronounced gone. Because no exterior wound was visible at first, students nearby did not even realize a shot had been fired. Wimberly fled on foot to a nearby restaurant, then called 911 herself. Fort Lauderdale police took her into custody within roughly an hour and recovered the firearm. Text messages pulled from her phone revealed that the night before, she had told friends she wanted to shoot Collette so that Amanda could feel the same pain she felt. Witnesses at the school identified her immediately. How does a girl who spent the night before cutting her own skin 90 times become someone capable of turning that violence outward by morning? The Broward County State Attorney direct-filed Wimberly as an adult on charges of first-degree murder and firearm possession on school grounds. The case was ultimately tried as second-degree murder with a firearm. Her defense team, led by Larry S. Davis, mounted an insanity defense built on her self-mutilation, her history of abandonment, and a delusional belief that she and Collette had been in a romantic relationship. Prosecutors pushed back hard, framing the shooting as a deliberate, jealous act by someone who had been rejected and wanted revenge. On December 9, 2009, after just 3 hours of deliberation, a Broward County jury rejected the insanity defense and convicted her of second-degree murder with a firearm. Judge John T. Murphy handed down the sentence on March 26, 2010. 25 years in state prison, followed by 20 years of probation. It was the same sentence length her own father was serving for attempted murder. At sentencing, the 16-year-old tearfully addressed Amanda's mother and told her she would never forgive herself, that the thought of what she had done made her physically ill. The Broward County School Board later settled a wrongful death lawsuit brought by Collette's parents for $525,000 without admitting fault. The 4th District Court of Appeal affirmed the conviction in 2012, and the Florida Supreme Court declined review that December. Multiple post-conviction motions filed by Wimberly herself were denied in 2017, 2018, and 2019. Because Florida abolished discretionary parole in 1983, she must serve 85% of her sentence under truth in sentencing law. Despite nationwide conversations about juvenile sentencing reform, no resentencing proceeding has been initiated in her case. As of 2025, Wimberly is 32 years old and remains in Florida Department of Corrections custody. Her earliest projected release falls around 2031. Wimberly's case turned on a single, devastating contradiction. A girl drowning in her own anguish who chose to pull someone else under with her. But some cases are not about a single moment of rupture. Some unfold across years, shaped by someone else's hands entirely. Janine Snyder. In April 2001, a 16-year-old girl from Las Vegas disappeared on her way to school. What followed was a 2-week ordeal that took her across multiple states, leaving her isolated and under constant control. When her life was ultimately taken, the person responsible was not the older man who had orchestrated everything, but his 21-year-old girlfriend, a woman whose own past raised difficult questions about influence and accountability. Janine Marie Snyder's story began years before the crime that placed her on death row. As a young teenager, she left home and became connected to Michael Forrest Thornton through his family. At first, it seemed like a place to stay, but over time, the situation shifted. Thornton, who was more than twice her age, introduced her to a harmful environment and gradually pulled her deeper into his world. What started as dependence slowly turned into involvement. By the time authorities began to understand what was happening, witnesses would later describe a pattern. Snyder would approach vulnerable teenage girls, gaining their trust before bringing them into Thornton's circle. Testimony in court suggested that this behavior had been repeated over several years, creating a disturbing picture of manipulation and control. One of those girls was Michelle Jessica Curran, a 16-year-old student at Western High School in Las Vegas. On April 4, 2001, she vanished while heading toward campus. Over the next several days, she was moved between locations, including motels and a private residence, kept isolated from anyone who might help her. Investigators later said she was kept in a state that made it difficult for her to resist or escape. On April 17th, at a rural property in Riverside County, California, her life came to an end. According to the case presented in court, Thornton directed the situation, but it was Snyder who carried out the final act. Her remains were later discovered on the same property, bringing a tragic end to the search. The case began to unravel when the owner of the property returned unexpectedly and reported unusual activity. Deputies responded quickly and detained both Snyder and Thornton. Inside a nearby structure, investigators found physical evidence that pointed to what had taken place, along with items that suggested planning and preparation. Authorities also discovered materials that raised concerns about whether other targets had been identified. The arrests led to a complex and highly publicized trial in Riverside County. Prosecutors argued that Snyder had become an active and willing participant over time, pointing to witness testimony and the repeated pattern of behavior. The defense, however, presented a different perspective. They argued that Snyder had been under Thornton's influence since she was very young, shaped by years of manipulation and unable to fully break away from his control. The trial, which began in 2006, lasted several months and included detailed testimony from multiple witnesses. Some described earlier encounters that followed a similar pattern, reinforcing the prosecution's argument that the actions were not isolated. Others focused on Snyder's background, highlighting her early vulnerability and the environment she had been pulled into. In the end, both Snyder and Thornton were convicted of multiple serious charges. The jury later recommended the death penalty, and the court formally imposed those sentences later that year. The decision reflected the court's conclusion that Snyder had crossed the line from influence into direct responsibility. In the years since, the case has remained tied up in a lengthy appeals process. Thornton passed away in 2024, while his case was still under review, bringing his legal journey to an end. Snyder, however, remains in custody in California, where executions have been under a statewide pause since 2019. Her case continues to raise difficult questions. Where does influence end and personal responsibility begin? Can years of manipulation fully explain someone's actions, or is there a point where choices become their own? For some, Janine Snyder's story is about control and exploitation. For others, it is about accountability and consequence. But for many, it remains a reminder of how complicated the truth can be, and how the line between victim and offender is not always as clear as it seems. Caitlin Coons. In April of 2023, a 17-year-old girl climbed out the window of her group home in Canton, Ohio, hid in her boyfriend's bedroom for several days, and then issued him a 5-hour countdown. Either he would take his own mother's life, or she would do it herself. He did nothing. She extended the deadline by 1 hour, and then she followed through. Caitlin Coons had been a ward of the state of Ohio for years. She cycled through multiple foster placements after abuse allegations against her biological parents, struggled with self-harm and disordered eating before she was a teenager, and repeatedly ran away from care. Her boyfriend, Jonathan R. Jones, was a 33-year-old Toledo area man and Afghanistan veteran. He had first encountered Coons when she was a child, and he was 30. By 2022, he was facing obscenity charges involving her and was on GPS monitoring with a court-ordered no-contact order. The order meant nothing. Around April 11, 2023, Coons climbed out a window of her Canton group home and traveled across the state to hide in Jonathan's bedroom for several days, all without his mother Nicole knowing anyone else was in the house. Nicole Jones was 53 years old, a resident of Sylvania Township just outside Toledo. She was Jonathan's mother. On April 19th, Coons delivered her ultimatum. When the deadline passed and Jonathan still had not acted, she retrieved a large rock from the yard, walked into the kitchen where Nicole stood at the refrigerator with her back turned, and struck her over the head repeatedly before strangling her. Jonathan remained in the next room. Together, they wrapped Nicole's body in tarps, placed her in the trunk of her own Buick Encore, and deposited the remains in an apartment complex dumpster. The dumpster was emptied and hauled to a landfill the following day. Nicole's body was never recovered. They fled south, carrying Nicole's jewelry, firearm, identification, and bank cards, cutting off Jonathan's ankle monitor along the way. After Jones missed a May 4th sentencing hearing on his existing charges, U.S. Marshals issued a nationwide alert. On May 6th through 8th, the pair were apprehended in northern Mexico. Coons confessed during a 2-hour FBI interview, walking investigators through the ultimatum, the rock, and the disposal with what detectives described as striking composure. She told agents she viewed Nicole as the obstacle preventing her and Jonathan from being together. Surveillance footage of the tarp and trash bag purchases, along with ankle monitor GPS data, corroborated every part of her account. How does a teenager who spent her childhood bouncing between foster homes arrive at a place where she calmly sets a timer on someone else's life? A Lucas County grand jury bound Coons over to adult court in January 2024 on charges including aggravated murder, felonious assault, aggravated burglary, aggravated robbery, tampering with evidence, and abuse of a corpse. Her bond was set at $1.75 million. Under a plea agreement, on June 4, 2024, both Coons and Jones entered no contest pleas before Judge Gary Cook to 1 count of aggravated murder and 1 count of abuse of a corpse. The remaining charges were dismissed. Judge Cook sentenced both to life in prison with parole eligibility after 25 years. Nicole's brother Robert delivered a victim impact statement in which he spoke of unimaginable betrayal and the particular horror of being denied any chance to lay his sister to rest, knowing her remains had been hauled to a landfill and lost. The no contest plea with an agreed life sentence forecloses most avenues for a direct appeal. Parole eligibility arrives in 2049 at the earliest, at the discretion of Ohio's Adult Parole Authority. Coons, now 20, is in Ohio Department of Rehabilitation and Correction custody. Robert Jones filed a wrongful death civil suit in April 2024, seeking $25,000 plus punitive damages. No resolution has been publicly reported. Coons issued a countdown and carried it out like a transaction. But across the Atlantic, a very different kind of violence was playing out on the streets of London. There was no countdown this time, no calculated deadline, nothing premeditated at all. Just 3 girls stepping off a bus with a bottle of vodka and an elderly man walking home from his regular pub. 3 Islington girls. On a Thursday night in late February 2025, a 75-year-old retired hotel worker was walking home along Seven Sisters Road in North London when 3 teenage girls stepped off a bus carrying a half-empty bottle of vodka. He raised his hands in a 2-fingered peace sign as they approached. Within seconds, they had backed him against a shop doorway and begun their attack. He repeated one sentence over and over. He just wanted to go home. The three defendants remain anonymous under United Kingdom reporting restrictions because all were under 18 at the time. The oldest was 17, the youngest 14, and the third was 16. All three had been in the care system. All three had documented histories of childhood adversity, and two had prior histories of self-harm. The 16-year-old already had 4 prior convictions, including racially aggravated harassment, and stored on her phone were 13 separate videos recorded over roughly 18 months showing the group attacking vulnerable people, including individuals experiencing homelessness. The youngest had already received a youth referral order in December 2024 for the attempted wounding of a homeless woman at a Sainsbury's in Archway. That attack, too, was filmed. Freddy Rivero had been born in Bolivia and had spent 25 years working at Duke's Hotel in Mayfair. He was a calligrapher, a chess enthusiast, and a cancer patient. He was 75 years old and walking the short distance home from his local pub. One of the girls pulled his glasses from his face. The 16-year-old kicked him in the leg. The youngest held up a phone and filmed. Then the 17-year-old struck him in the face. He fell backward, and his head hit the pavement. He suffered a traumatic brain injury and was taken to the Royal London Hospital, where he passed away the following day. What kind of pattern builds inside a group of children where attacking a defenseless stranger on camera becomes routine? The entire incident was captured on street closed-circuit television and on the defendant's own phone, giving Metropolitan Police a nearly complete evidential record. 2 of the girls were detained in a nearby park within hours. The third was arrested at home. When detectives examined the phones, they found the 13 additional assault videos. Initial charges of grievous bodily harm were upgraded to manslaughter on March 1, 2025. The case was heard at the Central Criminal Court, known as the Old Bailey, because manslaughter is classified as a grave crime under English law. On June 12, 2025, all 3 pleaded guilty to manslaughter before Judge Judy Kahn via video link. At sentencing on October 3, 2025, the prosecutor described the attack as unprovoked violence against a man who was particularly vulnerable by his age and failing health. Defense counsel for each girl cited their traumatic childhoods, and the 17-year-old read an apology letter in court. Judge Kahn called it a cruel attack on a completely defenseless elderly man and noted that Rivero had offered a gesture of peace before they even touched him. She imposed 4 years detention for the 17-year-old who threw the fatal blow, 3 years and 6 months for the 16-year-old, and 2 years and 6 months for the 14-year-old, all under Section 250 of the Sentencing Act 2020. The combined total was 10 years across all 3 defendants. Under standard release rules, each will serve half in custody and the remainder on license. Rivero's daughter publicly expressed disappointment with the sentence lengths. Islington North MP Jeremy Corbyn called the incident deeply shocking. As of late 2025, all 3 are held in youth offender institutions or secure children's homes, with their specific placements not publicly disclosed. The lead detective on the case stated that the fact they filmed the attack and found it amusing made the entire episode even more disturbing. Rivero's daughter said her father was simply one more name on their list. No appeals against conviction have been reported. The Islington case was fueled by alcohol and impulse and a group dynamic that had been rehearsed over a year and a half of filmed attacks. But in Oakland County, Michigan, the next case came down to something far more contained. A single moment of rage involving a household chemical and a sentence that left prosecutors stunned. Megan Joyce Emirovich. 2 days after turning 18, Megan Emirovich threw a handful of lye powder onto her sleeping father and poured water over him. The exothermic reaction that followed burned through more than 40% of his body. He spent 5 months in the hospital, lost both legs, and was eventually removed from life support. She was convicted of his death. Her sentence was time served. Megan lived with her 64-year-old father, Konrad Emirovich, in Groveland Township, Oakland County. Conrad was a chronic alcoholic whose blood alcohol concentration on the day of the attack measured at 0.255, more than 3 times the legal driving limit in Michigan. Her mother would later testify that the home was so cluttered and filthy, it looked like an episode of the television show Hoarders. On October 1st, 2021, Megan was scheduled to attend a salon appointment before her 18th birthday party, but Conrad was too intoxicated to drive her. Prosecutors argued this triggered her rage. While Conrad slept on the couch, Megan threw sodium hydroxide drain cleaner onto him and doused him with water. The chemical reaction and caustic fumes left him unconscious with severe burns. A friend later found him with his legs discolored green and his hands turned purple. Conrad was hospitalized for 5 months. He received skin grafts, underwent kidney dialysis, and had both legs amputated before he was removed from life support. He passed away on March 6, 2022. Michigan State Police recovered lye powder on the couch. Conrad regained consciousness briefly in the hospital, but said he could not identify who attacked him. His son Austin later testified that Conrad privately told him Megan was responsible. 4 cell phone videos Megan sent to a family friend showed her admitting she had thrown items toward the end of the sofa where chemicals were present. She also admitted in a recorded police interview to throwing bread and possibly water. She was arrested shortly after the incident. Did a missed hair appointment truly explain what happened on that couch? Or was something deeper and more corrosive already at work inside that house? Initial charges of assault with intent to do great bodily harm were upgraded to unlawful possession of harmful devices, causing death after Conrad passed, a felony punishable by life in prison. A misdemeanor domestic violence charge was added. The 4-day trial ran June 12th through 15th, 2023, in Oakland County Circuit Court before Judge Victoria Valentine. The prosecution, led by Assistant Prosecutor Jason DeSantis, argued this was a deliberate chemical attack by an enraged daughter who knew exactly what lye does to skin. Defense attorney Richard Miller countered that Conrad never identified Megan as his attacker, that his extreme intoxication made his account unreliable, and that the state had failed to prove she understood the lethal potential of what she threw. The jury convicted her on both counts on June 15th. Michigan sentencing guidelines recommended 51 to 85 months as a minimum. Prosecutors asked for 7 years. On July 25, 2023, Judge Valentine departed dramatically from those guidelines. She imposed 1 year in Oakland County Jail plus 5 years of probation, with approximately 506 days of credit for time served. That sentence effectively released her the same day she was sentenced. Throughout the proceedings, Valentine repeatedly characterized Emirovich as a child in terms of emotional maturity, stating that she did not believe someone of Emirovich's age understood the consequences of throwing those items at her father. The Oakland County prosecutor, Karen McDonald, responded publicly that Emirovich had lashed out in anger and ended up taking her father's life. In custody, Emirovich reportedly befriended Jennifer Crumbly, the mother of the Oxford High School shooter, who helped her draft her sentencing statement. The prosecution appealed, arguing the sentence was an abuse of judicial discretion and far below what the guidelines called for. On December 3, 2024, the Michigan Court of Appeals unanimously affirmed in an unpublished opinion, finding the trial court had provided sufficient justification for the departure. As of 2025, Emirovich remains on probation until July 2028. No violations have been publicly reported. She has given occasional media interviews since her release and was reportedly removed from the gallery during Jennifer Crumbly's trial in January 2024. Emirovich's case divided a courtroom over what a teenager can truly comprehend about consequences. But decades earlier, in a quiet neighborhood in northern England, 2 girls younger than she was answered that question in a way that left no room for interpretation. If you're liking this video and you're not subscribed yet, now's the time. We drop new cases every day. Subscribe so you don't miss the next one. Lisa Healy. In September of 1998, two teenage girls in Greater Manchester were invited into a 71-year-old widow's home for a cup of tea. What they did inside that home over the next several hours would lead a judge to call it an act of unbelievable cruelty. When they finally left, they took her body with them in a wheelie bin and dumped it into a canal. Then they used her phone to make 258 calls and spent her pension money on sweets. Lisa Healy was 15. Her co-defendant, Sarah Davy, was 14. The sentencing judge would later describe them as hard young women. No formal defense of mental illness or diminished responsibility was presented at trial, and no publicly documented history of abuse was advanced in mitigation. Lily was 71 years old, a widow who lived alone on West Street in Failsworth. Her only son, a mechanic, had emigrated to Tasmania in 1970. Neighbors described her as quiet, kindly, and profoundly lonely. Healy and Davy befriended Lily and were invited inside. Instead of sharing that cup of tea, they attacked her. They squirted shampoo into her eyes, slashed her legs with a knife, and tied a gag around her mouth so tightly that her dentures were forced into her throat, blocking her airway. She suffocated. Then they vandalized the home, scrawling their own names on the walls and carving them into the furniture. They threw her family photographs, including the picture of her son, into the bin. They placed her body into a wheelie bin, rolled it through the streets of Failsworth in full view of the neighborhood, and tipped it into the Rochdale Canal. Over the following days, they returned to the house repeatedly, making roughly 258 phone calls from her landline and using her pension money to buy crisps, chocolate, and sweets. How does a friendship offered in good faith become the very thing that costs someone their life? Lily's body was recovered from the canal 3 days after they disposed of it. The evidence needed no forensic breakthrough. The girls had written their own names on the victim's walls and carved them into her furniture. Witnesses in the neighborhood had seen them wheeling the bin through the streets. They had used her phone and pension card openly and made no effort to hide their identity. Both were detained within days. A childhood friend of Lily's son helped police trace him to Tasmania to deliver the news that his mother was gone. Both were charged with murder and tried at Manchester Crown Court before Mr. Justice Sachs in 1999. Both were convicted. Because both were under 18, they received detention at Her Majesty's pleasure. The mandatory indeterminate sentence for juvenile murderers in England and Wales, equivalent to a life sentence with a minimum tariff. Sachs imposed an 8-year minimum on each. He told them they had been convicted of an act of unbelievable cruelty, that 2 young girls had destroyed a frail old lady for totally pathetic reasons in order to take over her home, and that neither had shown the slightest trace of remorse or regret. Healy served approximately 11 years. In 2008, she was transferred to HMP Ascombe Grange, an open women's prison near York. While on day release, she formed a relationship with an inmate at the nearby HMP Moorlands named Michael Dent. She became pregnant and gave birth to a daughter in April 2009 at the prison's mother and baby unit. She was paroled shortly after. United Kingdom Social Services arranged a new legal identity for Healy and her child, and she was relocated under that protected name. She remains on life license, meaning she can be recalled to prison at any time for the rest of her life. Her co-defendant's path was far less stable. Sarah Davy had been recalled to prison 7 times by 2024 before being released again by the parole board in March of that year. As of 2025, Healy is believed to be living under her protected identity somewhere in the United Kingdom. No recall has been publicly reported. Healy was granted a new name, a new life, and a second chance the court never offered to Lily. But in the American Pacific Northwest, another teenager was about to discover that even the legal system's second thoughts can come years after the fact. Lola Luna. A prearranged fight between 2 16-year-old girls on a front lawn in Bremerton, Washington, lasted roughly 1 minute. One arrived with her fists. The other had a pocket knife hidden behind her back. 24 stab wounds later, the unarmed girl would never return to her 5-month-old child waiting in the car. Lola Felipa Luna was 16 years old with no prior criminal record. Her defense described her as a cheerleader who routinely carried a pocket knife for protection. Roughly 5 months before the incident, she had been in a fight at Kitsap Mall with a teenage acquaintance of the eventual victim, a confrontation reportedly rooted in social drama over a boy. Prosecutors would later introduce a Halloween 2020 TikTok video referencing The Purge, in which Luna held a kitchen knife, and an Instagram post referencing stabbing energy. Sienna Puryear Tucker was also 16. She was a young mother whose 5-month-old was in the car with friends when she arrived at Luna's home on Solaya Avenue. On Saturday, January 30th, 2021, around 12:26 in the afternoon, Puryear Tucker and 2 friends pulled up to Luna's house for a fight that had been arranged over social media. Luna came out to the front yard with the pocket knife concealed behind her back. Puryear Tucker swung first. Luna then used the blade, inflicting what investigators later counted as 24 stab wounds to her face, shoulder, neck, and back during a confrontation lasting roughly 60 seconds. The entire incident was captured on a neighbor's Ring doorbell camera. Puryear Tucker was rushed to Harborview Medical Center but did not survive. She was declared at 3:27 that afternoon. The Ring footage, the recovered knife, a 911 recording, statements from friends present at the scene, and the social media exchanges that set up the fight formed the backbone of the investigation. Luna sat through a roughly 5-hour custodial interview with Detective Garland after signing a Miranda waiver. Prosecutors described her demeanor during that interview as flippant. She did not learn that Puryear Tucker had passed away until the 5th hour, and at that point, she requested an attorney. Between her first trial and eventual sentencing, Luna became pregnant and gave birth. When a fight both girls agreed to ends with one of them gone and the other holding a blade, where does self-defense end and something else begin? On February 1st, 2021, Luna was charged as an adult in Kitsap County Superior Court with second-degree murder, both intentional and felony prongs, with a deadly weapon enhancement. Pre-trial rulings shaped the case significantly. The court admitted the Purge TikTok and the stabbing energy post as evidence of Luna's mindset. It excluded defense evidence that Puryear Tucker had received a threatening message described as a green light from a gang contact, which the defense argued would have shown Puryear Tucker was the true aggressor. The trial, delayed by the pandemic and by Luna's pregnancy, was held in late 2022. Deputy Prosecutor Joe Lombardi told the jury that when one person walks away with bumps and bruises, while the unarmed opponent suffers 24 stab wounds and does not survive, that is no longer a fight. Defense attorney John Cannon argued self-defense, describing Luna as a cheerleader, not a predator. The jury convicted her in December 2022. On January 30th, 2023, exactly 2 years after Puryear Tucker's passing, Judge Jennifer Forbes Hauser sentenced Luna to 168 months, which is 14 years. The Washington Court of Appeals affirmed in 2024. Then came the reversal. On October 30th, 2025, the Washington Supreme Court vacated Luna's conviction entirely and sent the case back for a possible retrial. Chief Justice Deborah Stevens wrote that Luna had not validly waived her Miranda rights, noting she was a newly turned 16-year-old with no prior police contact who had just sustained head trauma and believed she was required to cooperate with the detective. The court also cited cumulative evidentiary errors and invoked youth and adultification bias doctrine. As of April 2026, Luna's 14-year sentence is no longer in effect, and her status has reverted to pretrial. The Kitsap County prosecutor has not yet announced whether it will seek retrial. No new verdict or plea has been reported. Luna's conviction was erased by the state's highest court, her future now suspended between acquittal and a second trial. But in Polk County, Florida, another woman's legal fate followed the opposite trajectory. A jury voted for death. The judge said no. Cheyenne Jesse. On a Saturday in July of 2015, A 25-year-old woman drove her 6-year-old daughter to her father's rented home in South Lakeland, Polk County, hoping he would take custody. She did not leave either of them alive. She placed both bodies in plastic storage bins, moved them to a shed on the neighboring property, and padlocked the door. They remained there for nearly 2 weeks in the Florida summer heat. Cheyenne Nicole Jesse was 25 at the time. She had endured severe abuse by her mother during childhood and was removed from the home at 4 years old, placed into the custody of her father, Mark Ivan Weekly. At sentencing, the presiding judge described her as mentally and emotionally unstable and extremely depressed, and noted she had been controlled by her boyfriend at the time of the crime. That boyfriend was Matthew Monroe, who had recently ended their engagement over Jesse's chaotic and strained relationship with her 6-year-old daughter Meredith. Mark Weekly was 50 years old. Meredith Leanne Jesse was 6. On July 18, 2015, Jesse drove Meredith to Weekly's home. What followed was catastrophic. Meredith was shot once in the head and stabbed at least 4 times. Jurors were told she had been asleep in a pink dress. Weekly was shot 3 times in the head and stabbed at least 12 times. His body showed defensive wounds consistent with a struggle. Jesse placed both into plastic storage bins and transported them to a shed on the landlord's adjacent lot. The Florida heat accelerated decomposition. Neighbors reported a foul smell. Jesse told them it was a dead raccoon. On August 1st, under pressure from Weekly's concerned friends, Jesse reported her father and daughter missing. Her story shifted repeatedly. She first claimed Weekly had a terminal illness and took Meredith to spend his remaining days. Then he said they were in Georgia. Then she claimed self-defense. After a 4-hour interrogation, she confessed and gave detectives the key to the padlock. The Polk County Sheriff described her publicly as a cold-blooded offender. If Meredith was the perceived obstacle to her relationship with Monroe, what explains what happened to Mark Weekly in that same house on the same afternoon? Jesse was charged with 2 counts of first-degree murder and tampering with physical evidence. The state sought the death penalty. The 13-day trial took place in July 2019 before Judge Jalal Harb in Bartow, with Assistant State Attorneys Paul Wallace and Christy Ducharme leading the prosecution. Their motive theory was direct. Jesse ended both lives to salvage her engagement to Monroe, who had grown tired of Meredith's behavioral issues and made clear that the child was the reason he was leaving. Defense counsel Deborah Tuomi argued it was actually Monroe who had committed the acts, pointing to his internet search history as evidence of intent. Prosecutors countered that no physical evidence, no DNA, and no witness testimony linked Monroe to the scene. On July 17, 2019, the jury convicted Jesse on all counts. During the penalty phase 2 days later, the jury unanimously recommended death for Meredith's passing and voted 10-2 for life imprisonment for Weekly's. The judge did not follow the jury's recommendation. On February 5, 2021, nearly 18 months after the verdict, Judge Harb declined to impose death. He stated that Jesse should lose her liberty but not her life, citing statutory mitigating factors, including extreme mental or emotional disturbance and substantial impairment of her capacity to appreciate the criminality of her conduct. He imposed 2 consecutive life sentences without the possibility of parole. The Florida 2nd District Court of Appeal affirmed in 2022 under case number 2D210483. No successful post-conviction challenge has been reported. Per Florida Department of Corrections records, Jesse is housed at the Florida Women's Reception Center near Ocala under close custody. Her release date is listed as sentenced to life. She is approximately 36 years old. Jesse's judge overrode a jury's call for death, citing a mind too fractured to face the ultimate punishment. In Western Sydney, another case would test that same boundary even further, with a defendant whose mind was not merely troubled but clinically impaired, and whose actions defied every measure of proportion. Jessica Camilleri. On a Saturday evening in Western Sydney, a 25-year-old woman and her mother argued over a second takeaway food delivery. Within minutes, the daughter had retrieved 7 kitchen knives from the drawer. 4 of them broke during what followed. When it was over, she carried what remained of her mother through the front door and out onto the footpath. Jessica Camilleri was 25 and lived with her mother Rita, 57, in the suburb of St. Clair. She had been diagnosed with autism spectrum disorder, intermittent explosive disorder, obsessive-compulsive disorder, borderline intellectual disability, anxiety, and panic disorder. She had been relentlessly bullied at school and had developed a fixation on violent horror films. Police later recovered 8 copies of the Texas Chainsaw Massacre and 5 copies of Jeepers Creepers from the home. In April of 2019, roughly 3 months before the incident, Jessica stopped taking her prescribed mood-stabilizing and antipsychotic medications in favor of naturopathy. Rita Camilleri had been making plans to have her daughter admitted to a mental health facility. On Saturday evening, July 20th, 2019, mother and daughter argued about a second delivery from the fast food chain Red Rooster. When Rita picked up the phone to call an ambulance and have Jessica admitted, Jessica ripped the phone from her hand. The struggle moved into the kitchen. Jessica used 7 kitchen knives in sequence. 4 of them snapped during the assault. She inflicted at least 100 stab wounds concentrated on her mother's head and neck. She severed her mother's head and removed her facial features. A 4-year-old nephew was present elsewhere in the home. Jessica then carried her mother's head outside, reportedly intending to show a neighbor as evidence of what had happened. It slipped from her hands onto the footpath. Jessica called 000 herself. When paramedics arrived, she asked them whether they could work miracles. She made admissions during a recorded interview that same night. When every clinical diagnosis pointed toward a mind in crisis, and every piece of evidence pointed toward an act beyond comprehension, how does a legal system even begin to weigh one against the other? Charged with murder on July 21, 2019, Camilleri offered pre-trial to plead guilty to manslaughter. The Crown rejected the offer. Her trial was held in the Supreme Court of New South Wales before Justice Helen Wilson in December 2020. The jury heard competing psychiatric testimony. Crown expert Dr. David Greenberg and defense expert Dr. Richard First offered sharply different assessments of her mental capacity at the time of the act. On December 10, 2020, the jury returned a verdict of not guilty of murder, but guilty of manslaughter on the basis of substantial impairment by abnormality of mind under Section 23A of the New South Wales Crimes Act. On March 12, 2021, Justice Wilson called the crime as serious an example of manslaughter as there can be, a crime of extraordinary viciousness and brutality. She imposed 21 years and 7 months with a non-parole period of 16 years and 2 months. On appeal, the New South Wales Court of Criminal Appeal upheld one ground. The original sentence had not adequately discounted for her early manslaughter plea offer and had given insufficient weight to her diminished moral culpability stemming from her cognitive impairments. The court resentenced her to 16 years with a 12-year non-parole period, originally set to expire in July 2031. But Camilleri's time in custody has been defined by continued violence. She ripped hair from correctional officers' scalps in August and October of 2021 and committed further assaults in March 2022. In September 2023, she received an additional 22 months for assaulting officers, pushing her non-parole date to roughly July 2032. In June 2025, she pleaded guilty to yet another common assault. On appeal, a judge varied the sentence to be partly concurrent, trimming approximately 4 months. As of 2026, Camilleri remains at Dilwynia Correctional Centre in New South Wales. Her non-parole date falls in approximately mid-2032. Camilleri's case was shaped entirely by a mind the court recognized as severely impaired. But in rural Wisconsin, the final case on this list presents something raw. A household saturated with documented abuse, a teenager with a horror blog and a loaded shotgun in the next room, and a question the sentencing judge struggled to answer. When does a lifetime of violence suffered become an explanation for violence committed? Ashley Martinson. The night before she ended 2 lives, a 17-year-old girl in rural Wisconsin posted on social media that she wanted to take one of her stepfather's guns and blow his brains out. She was 1 day past her birthday. By the next morning, she had done exactly what she described. And then she turned the violence on her own mother. Ashley Ann Rose Martinson was born into generational trauma. Her mother, Jennifer, had been abused as a child herself and emancipated at 16. Ashley alleged that a former boyfriend of her mother's had harmed her repeatedly during her childhood, including burning her with cigarettes, while Jennifer failed to intervene. In 2011, Jennifer married Thomas Ayers, a man whose criminal record stretched from 1998 across Kansas, Colorado, and North Dakota, including domestic battery, kidnapping, child enticement, and abuse. Though legally barred from possessing firearms, Thomas kept multiple loaded guns in the family's rural Peel Township home. Court records and testimony from younger siblings confirmed he beat Jennifer, struck his biological daughters with belts, held a gun to Jennifer's head over trivial disputes, and slaughtered baby animals in front of the family, including the family dog. Ashley ran a horror blog titled Nightmare under the pen name Vamp Chick. Its homepage read that if you were ready, she would paint the streets red just for you. She was later diagnosed with post-traumatic stress disorder and depression. The family had recently discovered Ashley's relationship with 22-year-old Ryan Daniel Sisko and revoked her car and phone privileges. On the night of March 6, 2015, Ashley posted on Facebook that Thomas was going to end her mother's life if Jennifer did not leave soon, and that she wanted to take one of his guns and use it on him. On the morning of March 7th, 1 day after her 17th birthday, Ashley witnessed Thomas beating Jennifer. She retrieved a 12-gauge shotgun and brought it to her room, later saying she intended to use it on herself. When Thomas pounded on her bedroom door, she fired twice and took his life. When Jennifer came upstairs, a confrontation followed. Ashley stabbed her more than 30 times with a kitchen knife, taking her life as well. She then tied her 3 younger sisters into a bedroom, left them food and juice, placed cartoons on the television, showered twice, and fled with Sisko in a 1999 Chevrolet Silverado. The oldest surviving sister, 9 years old, freed herself and called 911 at 10:43 the following morning. Oneida County deputies found both bodies, the shotgun, a bloodied kitchen knife, and 3 unharmed children. That evening, authorities in Boone County, Indiana stopped Martinson and Sisko as they headed toward Tennessee. Sisko was never charged in connection with the deaths. Ashley initially claimed self-defense and told investigators that her mother had been the one who shot Thomas. Her sister's accounts contradicted that version. If the house itself was the source of the danger, and every adult in it had either inflicted harm or failed to stop it, what options did a 17-year-old realistically believe she had left? District Attorney Michael Sheik charged Martinson as an adult, which under Wisconsin law was automatic at age 17. She faced 2 counts of first-degree intentional homicide and 3 counts of false imprisonment. She initially entered a plea of not guilty by reason of mental disease or defect. Under a plea agreement reached on March 11, 2016, the state reduced the charges to second-degree intentional homicide, conceding it could not disprove adequate provocation beyond a reasonable doubt. She pleaded guilty before Judge Michael H. Bloom. At sentencing on June 10, 2016, prosecutors asked for 40 years of confinement. Defense counsel Mark Schoenfeld sought 8, citing the extensively documented abuse in the household. Judge Bloom imposed concurrent bifurcated sentences of 23 years of initial confinement, followed by 17 years of extended supervision. He acknowledged the abuse but concluded Ashley still had a choice. A 2017 post-conviction motion was denied. The Wisconsin Court of Appeals affirmed in 2019. In May of 2025, Martinson filed a motion from Taycheedah Correctional Institution seeking to vacate or modify her sentence, citing her rehabilitation efforts and a high school diploma earned in custody. On September 3, 2025, Circuit Judge Mary Sawinski denied the motion without a hearing. Because Wisconsin abolished traditional parole for offenses committed after 1999, Martinson is not eligible for early release in the conventional sense. She remains at Taycheedah Correctional Institution in Fond du Lac. Her projected release to extended supervision is February 28, 2038. Supervision will continue until approximately 2055. 10 cases, 10 different lives, 10 different courtrooms that tried to make sense of what happened and why. Thanks for watching. Click here for the next video.